Thank you. Good morning. My name is Jarek Gandolfo. I'm an assemblyman from New York and also the vice chair of the NCOIL Joint State Federal Relations and International Insurance Issues Committee. I will be your moderator for this general session this morning, and again, thank you all for joining us. We have a great panel of speakers here with us today to discuss a very important and interesting topic centering on ERISA on its 50th anniversary. Is it an important standard setter or a roadblock to state healthcare innovation? If you've been involved in NCOIL throughout the past several years, you likely know that NCOIL supports the position that ERISA has grown far beyond its original intent of establishing uniform federal standards to protect private pension plans from fraud and mismanagement, and has transformed into a critical barrier for states seeking to enact meaningful healthcare reforms. When ERISA was passed, about 7% of employees had coverage through self-funded plans. That number has ballooned to 61% as of 2019, and there is reason to believe that the percentage has increased since then. NCOIL is supportive of Congress amending ERISA to add a statutory waiver provision so that protections set forth in state health insurance plans, state health insurance laws apply to all health insurance plans, including self-insured plans. In fact, there's a draft statutory waiver provision in your binders on page 178 and on the website and the app. That language has been supported by Congressman Pete Sessions, and we expect him to introduce it very soon. With all that said, the discussion today won't be one-sided. We will hear from both sides of the issue and different perspectives as to why ERISA should be modified or why it shouldn't be modified. Joining us today to discuss these issues are Melissa Bartlett of the ERISA Industry Committee, Carmel Shakar of Harvard Law School, Katie Johnson of the American Benefits Council, and Randall Markarian of the American Dental Association Special Committee on ERISA. To learn more about these speakers, you can view their bios in the program and also on the app. We won't read them right now. I also urge all of you to reach out to them afterwards to learn more and ask any additional questions you might have. In terms of speaking format, we'll hold all questions until every panelist has finished their presentation. And we'll get started now. And first up, we will hear from Carmel. Go ahead, please.
Hello, everybody. Thank you for having me. So as mentioned, I'm Carmel. I'm an assistant clinical professor of law at Harvard Law School, which is exactly how it appears in Legally Blonde. I'm also faculty director of the Health Law and Policy Clinic at the Center for Health Law and Policy Innovation of Harvard Law School, where we work on access to care, in particular for individuals living with chronic illnesses, disabilities, and lower incomes. I'm here today to give you guys a roadmap of ERISA, where it came from, where it stands right now, as well as to flag how it does and doesn't interact with state attempts at healthcare reform. Excellent, the slide changer moves. So what I'll do is give you a brief introduction of ERISA, and apologies, I know probably a lot of you guys very much are aware of what ERISA is and what it does, because you probably have some creative ideas that occasionally you're told, no, you can't do that, ERISA. But we'll dive into the statutory language. We'll talk about some of the major Supreme Court cases. We'll talk about the impact on state health care reform, as well as evaluate some of the pros and cons of the potential solution of waivers that Jarrett flagged. So the first case is, what exactly is ERISA? And here I will say ERISA is the kind of topic that even among law professors, when we talk about it, people groan and go, oh my gosh, ERISA. I think it's really interesting. I tried to convince my husband to name our dog ERISA, but he put his foot down, so her name is Ellie instead. So what you fundamentally need to know about ERISA is that it is the federal law that sets minimum standards for most voluntarily established pensions and other employee benefit plans. When it was established in the 70s, there was a real sense that the fact that states were putting different restrictions on employee benefit plans was a real challenge to convincing employers to provide these plans. And in general, it's a really good thing for employees to have access to these kind of services. And so from the very start, it articulated a vision of the regulation of ERISA plans as an exclusively federal concern. They wanted standardized financial disclosure and reporting requirements. Reporting requirements, believe it or not, will become important a little bit later in my presentation. Standards of conduct, responsibility, and obligation. And it included what's called a preemption clause, meaning that it says, okay, only the federal government operates in this space. States like, go take a nap. And it says all state laws insofar as they relate to any employee benefit plan. And this preemption clause is really interesting because it is by far one of the broadest and most expansive that you can find in federal legislation. And again, the purpose was really to allow multi-state employers to offer a single consistent plan to all of their workers, reduce administrative and regulatory burdens while keeping administrative costs low, which I think we can all agree, to quote Martha Stewart, is a good thing. For a while, the kind of traditional court approach to ERISA was that when a state statute was deemed to violate ERISA preemption when it had, quote, a connection with or reference to covered employee benefit plans. Now, I'm sure a lot of you have gone to law school, and so you can recognize vague, expansionist, ultimately unhelpful standards when you hear them, and that kind of language, it doesn't provide a lot of guidance as to, okay, what is in ERISA world and what is fair game for states to regulate. This is especially an issue because ERISA was never intended to be a healthcare statute or to articulate any sort of vision of health policy. ERISA governs employer-sponsored healthcare plans or insurance plans in which employers cover the full financial risk of its employees' claims for healthcare. Employer-sponsored insurance covers a lot of people. It covers almost 159 million non-elderly people in this country. In 2022, about 65% of workers who got their health insurance through their employer were enrolled in plans that were at least partially self-funded, meaning that ERISA would apply. Larger companies are more likely to offer employer-sponsored healthcare plans. About 20% of covered workers at small firms are in one of these plans, but 82% in large firms are enrolled in plans that are self-funded. So now we're going to go back to the 90s, which I will tell you as somebody who teaches a fresh crop of 25-year-olds every year is like very trendy now. So this presentation is on trend because that's when the last major ERISA jurisprudence push happened. And so there's 3 cases in the 90s that are really important to know for ERISA background. And the most significant of them is a case, New York State Conference of Blue Cross and Blue Shield versus Travelers Insurance Company. So hailing from Jarrett's home state and from my home state. And this case was a 1995 case concerning a New York state law that required hospitals to collect certain charges from commercially insured patients, but not from patients covered by Blue Cross Blue Shield plans. These charges were intended to cover the cost of treating uninsured patients. And Travelers was really notable because the Supreme Court, when it got to them, tried to curtail ERISA's preemptory reach and concluded that the New York state law actually was not preempted by ERISA. The Travelers Court noted that nothing about ERISA or its legislative language indicated that Congress chose to displace general healthcare regulations, which historically have been a matter of local concern. And Travelers, as this case is called, together with 2 other cases, one from 1997, set the modern test for ERISA preemption for state healthcare laws, which is that a state law runs afoul of ERISA preemption when it mandates employee benefit structure or their administration, basically when it forces a choice. And this is where the law stood for quite a while until we get to Gobiel versus Liberty Mutual in 2016. This is a case in which Vermont had what's called an all payers claim database, where they wanted insurers to report in the claims that were made. These databases are very helpful for understanding healthcare cost, healthcare spending, tracking, okay, what is being delivered. And it was also notable because it was a case that really bought into vision of ERISA as very expansive. The majority opinion said that ERISA preempts Vermont's all-payer claim database because the Vermont law had a connection with an ERISA plan. It governs a central matter of plan administration, in this case, reporting, and it interferes with a nationally uniform plan administration. One thing that was notable is that this case is the first time that the court considers future problems with uniformity in ERISA preemption jurisprudence, rather than focusing on whether the state law as currently applied resulted in uniformity issues. Because ERISA plans were not required to report this type of information to the Department of Labor, but under ERISA, they could be made to in the future. So the dissent thought that this was really overreaching, that the Vermont law did not impermissibly intrude onto ERISA's dominion over employee benefit plans because it didn't impose a substantial burden on ERISA, and that the Vermont law and ERISA's current reporting requirements elicited different information and served distinct purposes. And so the dissent said, hey, you could do both reporting with minimal burden. The next modern case is Rutledge versus Pharmaceutical Care Management, and that comes from 2020. That is a case in which Arkansas tried to regulate how much PBMs would pay for generic medications. And this case, I think you can read directly as a reaction to GoBL being quite expansive. So in this case, the Supreme Court said ERISA does not preempt Arkansas's regulation of pharmaceutical benefit managers and drug pricing because the act did not refer to ERISA because it applied to PBMs whether or not they managed an ERISA plan. It was ERISA neutral. What's interesting is that Sotomayor, who writes the majority opinion, really tries to connect this case back to the New York cases, back to Travelers, and only mentions GoBL 3 times in passing, basically trying to walk away from this high watermark of ERISA preemption. So Roberts, who writes the dissent, sorry, I apologize, not Roberts, Thomas, who writes the dissent, on the other hand, really engages with GoBL, saying, okay, I don't think we can distinguish Rutledge from GoBL. But he doesn't say GoBL is a good case. He says that he's really unhappy with the Supreme Court's ERISA jurisprudence overall, saying that it offers little guidance or predictability. And in his view, the court would be better suited to return to the text of ERISA, and he would have decided this case on a more straightforward ground that there is no ERISA provision that governs the same matter as Act 900. And this is where the Supreme Court has left off when it comes to ERISA, kind of acknowledging that it's a little bit of a pendulum, that the standards that it articulates for when ERISA prevents states from doing healthcare reform or healthcare initiatives is vague, unhelpful, at times not altogether coherent. And this does have an impact on what the states are able to do in terms of healthcare reform. So I have a colleague, Liz McCuskey, who did really great work analyzing all of the different types of state healthcare reforms that have been prevented by ERISA preemption. The truth is that if you're looking to do something universal in your state that applies everywhere, how are you going to reach the employer self-funded plans becomes a really big challenge. The other thing I want to say is that GoBL operates as a bit of a test case. So we know that GoBL has significantly reduced the volume of claims data available to all payer claims databases. They're seeing about 30% less data, despite the fact that some states have tried to work around it by encouraging voluntary submissions. And we see employers saying, okay, well, now that I'm not legally required to, I'm worried that if I do give you this data, am I violating HIPAA? Am I violating non-disclosure agreements? And so there's a reluctance there. And I would argue that GoBL shows that ERISA fixes at the federal level are unlikely. So in the GoBL case, Stephen Breyer explicitly says, hey, the Department of Labor could work with Health and Human Services to create carve-outs for reporting, just saying, okay, here's the data that states collect. Great, ERISA plans, send that data to us and we'll share them with the states. And there's been no political appetite. The Department of Labor, which is in charge of administering ERISA plans, tends to be very minimalist in its approach. I think they correctly see themselves as not having that deep knowledge of healthcare. And so they regulate them primarily from the employer welfare perspective. Like, is this plan being administered correctly? You see this with states trying to create some sort of single payer plan where very similar schemes kind of succeed or fail depending on which courts they hit. Maryland tried to get employers with more than 10,000 employees to spend a minimum of 8% of their payroll on healthcare. And they said, you don't have to give us that money. You don't have to spend it on healthcare. You could also just pay it into our state Medicaid fund. The Fourth Circuit struck down what was called that fair share law because they argued the only rational choice that large employers had was to spend the required amount of money on healthcare, because otherwise the employer got no benefit if it just gave the money to the state. San Francisco did something fairly similar. In this case, the Ninth Circuit thought that it didn't violate HIPAA because the ordinance applied regardless of whether the employer had an ERISA plan. They said it didn't relate to ERISA-governed health plans. And it distinguished it from the Fourth Circuit because it said, okay, employers in this case do have total discretion about how to spend their mandated contributions. I think as states get interested in figuring out health coverage, you'll see more of these cases, and eventually one of them will probably make its way to the Supreme Court for a resolution. So I wanted to spend a couple minutes talking about the waiver solution. And this is a proposal to allow the Department of Labor Secretary to grant waivers of ERISA preemption. A state would have to proactively pursue a waiver of ERISA preemption, and it could only use it for regulations touching health plans, not other benefit plans. I feel very lucky to have hit upon this topic because in my other work, I do a lot of work with what are called 1115 Medicaid waivers. And so I see a lot of the benefits, but also the challenges to kind of hinging a lot of your policy on waivers. So what is nice about this approach is it doesn't get rid of ERISA or ERISA preemption, but it sort of recognizes a little bit of what I would call its mission creep, to say that ERISA wasn't intended to block a lot of work being done in the healthcare sphere. It also wouldn't add significant cost to the federal government, which is probably a good selling point at this current political matter. But the challenge of waivers is that they can be very dependent on political wins. And I see this in the work with 1115 Medicaid waivers, where the Trump administration was very supportive of 1115 Medicaid waivers that included work requirements. And the Biden administration came in and actually tried to rescind approval of those waivers, which went to court. They weren't successful, but undoubtedly, if those waivers expired during a Biden or a Harris administration, they would not have been renewed because those administrations took a stance that work requirements were really problematic in Medicaid. You see that with health-related social needs waivers also being put in these waivers. The concern, okay, what happens when this expires and the administration isn't so friendly to it? And so one concern with waivers, and I believe this one suggests a term of 5 years, is if you're trying to build kind of long-term, durable, big changes in your state's healthcare industry, and you're hanging it on a waiver that lasts only 5 years, and you can't predict which administration might be reviewing the renewal, it's a little hard to get people to truly buy in. The other thing I want to flag is that we are in a very interesting moment when it comes to what's called administrative law. Some of you have heard of the Loper-Bright case, which basically undoes the kind of long-standing rule of thumb that courts are supposed to give a lot of deference to federal administrative agencies interpreting their own statutes. And so I would flag that there's a little bit of an element of unpredictability as to whether courts would look at the Department of Labor's waivers and say, like, yes, that's appropriate, or if they would try to substitute their judgment. So in all, I think waivers are a good idea to kind of move around the ERISA preemption bottleneck. But like with virtually everything in life, nothing is 100% perfect and peaches and creams. There are some considerations that you would need to think about going down the waiver route as opposed to trying to argue for a legislative revision to limit the scope of preemption in healthcare, or whether you might say, you know what, the status quo is working. We think that this is fine and that there's something different about employer-sponsored insurance. We're comfortable with the level of preemption that currently exists. So with that, I will hand it over.
Thank you. Melissa, you're on the clock.
Thank you. Good morning. I'm Melissa Bartlett, Senior Vice President of Health Policy for the ERISA Industry Committee, otherwise known as ERIC. Thank you for inviting me here today to share a few words about the importance of ERISA preemption to ERIC's membership. ERIC is a national nonprofit organization exclusively representing the largest employers in the United States in their capacity as sponsors of employee benefit plans for their nationwide workforces. ERIC member companies offer comprehensive benefits, including retirement plans and health coverage for employees, their families, and retirees. They do so to attract and retain employees, to be competitive for human capital, to improve health and productivity, to prepare for retirement, and to provide peace of mind. The ERISA benefit system is huge. I know today we're talking about health care, but ERISA preemption also impacts retirement. The private sector alone holds something like $12 trillion in retirement assets, not including $11 trillion held in IRAs. There are almost 70 million active employees participating in 401k plans, plus former employees and retirees. And more than 22 million Americans in the private sector continue to have access to a traditional defined benefit pension. But for purposes of my comments today and the focus of today's session, I'll focus on the importance of ERISA preemption specifically for self-insured ERISA health benefit plans. Employer-sponsored coverage, the single largest source of coverage in our country, so my number says covers 180 million Americans, so maybe that includes the retirees. Okay. Self-insured employers pay on average of 70 to 85% of employees' premiums. Employer-sponsored insurance is the largest source of health insurance in the country, surpassing government programs like Medicare, Medicaid, and CHIP. Employers develop value-driven and coordinated care programs, implement employee wellness programs, provide transparency tools, and a myriad of other innovations that improve quality, reduce costs, and drive value for working families. However, to help inform policymakers regarding the best policies that can help employers continue to offer their great benefits, we at ERIC constantly pose questions to our membership. What are you most worried about? What threats pose a challenge to your companies and to your plans? What should ERIC be working on? The answer always reflects concern about the ability to offer uniform benefits nationwide. In other words, it's preemption, and then quite literally everything else. That might seem extreme, but think about a world where 50 states can regulate the minutia of each and every plan. In the healthcare world, that means employees in different states having different healthcare coverage for the same healthcare service or treatment, thus creating inequities in their health benefits and compensation. The result would be chaos and the end of the private sector providing benefits on a voluntary basis. So why was ERISA created? And I think Professor has touched a bit upon it in her comments, but as you recall, the Studebaker Corporation closure in South Bend, Indiana in 1963 was a major factor in Congress's decision to enact ERISA. Studebaker terminated pension plans for hourly workers where the plan defaulted on obligations. The United Auto Workers and others seized this opportunity to push for federal regulation, with President Ford signing ERISA into law in 1974. Happy birthday, ERISA. It's ERISA's 50th birthday. It was a bipartisan bill with only a handful of members voting against it. A provision in the conference committee was added that significantly enhanced the preemption of state laws. Since then, ERISA has been changed at the federal level several times through COBRA, HIPAA, the Mental Health Parity Act, otherwise known as MAPIA, GINA, and the Affordable Care Act, just to name a few in healthcare alone. Today, ERIC's mission is to protect and uphold the principles of ERISA preemption. We strive to preserve and reinforce ERISA preemption and defend plan sponsors' ability to design benefits that drive value. We oppose any attempt to mandate state reporting or other administrative obligations on companies that offer ERISA-regulated plans. To restate, the core aim and effect of ERISA is the creation of uniform national standards for employers to use when designing and administering valuable employee benefits. Unfortunately, the nationwide uniformity in benefits that ERISA provides are being increasingly threatened by efforts to regulate at the state level healthcare or retirement benefits more broadly. When different states approach benefit policy issues individually, they unavoidably create an inconsistent patchwork of state laws that, absent broad preemption by federal law, employers must constantly adapt to and comply with. All too often, these laws feature directly conflicting provisions as well. In that case, an employer cannot simply split the difference and design a single benefit structure and administration platform that complies with both state laws at once. The result is a fractured benefit administration that forces employers to design and administer satellite plans in jurisdictions that enact such laws, creating uneven and confusing benefits across a workforce. This balkanization of multi-state employer benefit plans drives up administrative and compliance costs and ultimately reduces the resources that can be used to provide valuable employee benefits. This inefficiency is precisely what Congress intended to avoid by enacting ERISA in the first place. As bills are drafted, introduced, and discussed, we ask that legislators like yourselves work with us to better understand the narrow ERISA preemption issues that our member companies are concerned with, and to include explicit exemption language clearly stating that self-insured ERISA employer plans are exempt from state law provisions. Short of this exemption language, ERIC opposes any bill that would impact the design or administration of self-insured ERISA plans. A few key areas where we see states tend to overreach and undermine ERISA's preemption include state pharmacy benefit manager laws, otherwise known as PBM laws. These laws mandate specific pricing terms for existing contracts between employers and their PBMs. While ERIC shares states' concerns regarding the need for PBM transparency and the need to address the very certain bad practices that are being employed, such efforts should not be overreaching to pull in regulation of self-insured ERISA plans. Again, we strongly share the concerns of states, and we are working hard at the federal level to bring PBM transparency and accountability reforms to the market. All payer claims database. As Carmel mentioned, the Supreme Court ruled in Gobiel that a state may not require an ERISA plan to participate in a state APCD. Congress further confirmed this when it passed legislation that directed the Department of Labor to build a standardized reporting format enabling voluntary participation in state APCDs by ERISA plans. We recommend that states access claims data through a federal clearinghouse, ensuring employers report only to the Department of Labor and not to any state authority. Providing a single nationwide data submission versus individual submissions for each state would reduce the employer's administrative burden and plan costs. Lastly, states have health reform efforts that often seek to mandate the level of health care coverage employers must provide, a clear violation of ERISA when applied to self-funded or self-insured health plans. States are primarily doing this in two ways: by levying assessments on payers and including new mandates in the Affordable Care Act, Section 1332 state innovation waivers. I will close by sharing a few thoughts and feedback on the proposed ERISA waiver concept that you raised. The proposed Section 514F is not, I will pose, necessary, desirable, fair, or constitutional. To take fairness first, noted ERISA scholar James Wooten has argued that ERISA's broad preemption provision was part of the historic compromise necessary to unite the employer community and organized labor behind passage of ERISA. To summarize, ERISA wouldn't have seen the light of day but for the preemption section. The legislative history of ERISA Section 514 illustrates the broad scope of ERISA's preemption provision, as articulated by one of ERISA's chief sponsors at the time, Representative Dent, and this is his quote from the legislative history 50 years ago. Finally, I wish to make note of what is to many the crowning achievement of this legislation, the reservation of federal authority, the sole power to regulate the field of employee benefit plans. With the preemption of the field, we round out the protection afforded participants by eliminating the threat of conflicting and inconsistent state and local regulation, end quote. As for necessity and desirability, proposed Section 514F is a major threat to large multi-state employers. If adopted, the effects would be immediate, widespread, and destructive of the interest of employees. Even the existence of such a scheme frustrates the very point of the deal struck in ERISA, federal regulation in exchange for national uniformity. Finally, the proposed Section 514F is of very dubious constitutionality. It allows for an action having the effect of amendment or vetoing ERISA. Parallels can be drawn to Clinton versus City of New York, where the Supreme Court struck down the Line Item Veto Act of 1996 because it permitted the president to cancel some provision of an appropriations bill after having signed the bill into law. Here, Section 514F has an even more pernicious effect, allowing the cancellation of Section 514A, the preemption section, by an unelected cabinet officer who is not directly accountable to the people. Additionally, proposed Section 514F arguably violates Article 1 of the Constitution, which vests all of the legislative power granted to the federal government in the Congress, and there is no provision of the Constitution that authorizes a state to play any role in the exercise of that power. Again, thank you for having me today, and I'm happy to answer any questions.
Thank you very much. Rendell, go ahead, please.
Good morning. My name is Randall Markarian, and I'm an orthodontist in Southern Illinois, an ADA trustee for the American Dental Association, and I chair the ADA's Special Committee on ERISA. Thank you very much for allowing me to speak today. As you know, the American Dental Association believes in ERISA preemption, but preemption has obviously gone well beyond its original intent and is now being used as a blanket shield by insurance companies against state laws that legislators like yourselves have passed to protect consumers and providers. We believe that most of the state laws designed to protect, it would probably help if I click my slides, designed to protect patients and providers should not be preempted by ERISA. In general, preemption should be limited to those topics that Congress originally intended to reserve for federal oversight, such as who qualifies as a beneficiary, what benefits are provided, and other core administrative decisions about how the plan is organized. I was going to give you a short recap of what's going on legally, but I think we've already had a good recap of that already this morning. So I'm going to move ahead and talk about some laws that the ADA and state dental associations have worked to get passed over the last decade or more that have benefited consumers and the dental providers. I'm just going to show 4 laws. We have prior authorization laws, virtual credit card laws, network leasing laws, and non-covered services laws. And those have been passed in a large number of states. And let's talk about some of the benefits that these laws have. For example, prior authorization. Prior authorization, the plan is indicated to a patient and the dentist that services will be paid for at a certain amount. It acts as sort of a promise to pay from the dental benefit company to the dental office and the patient. Pretty basic, but let's see how that applies to prior auth laws passed in states. First, they do not mention ERISA. Second, they do not dictate plan design. So preemption should not be triggered. A dental carrier should therefore not be able to say it will pay out as it is promised if it is paying a claim for one of its fully insured plans, not paying the promised amount because the carrier is paying on behalf of a self-funded plan, claiming ERISA preemption harms both the patient and the dental provider, the doctor, who expected a certain amount to be covered by the plan. Similarly, with virtual credit cards, No preemption should be triggered. Laws passed on this issue simply allow the dentist to opt out of certain payment methods and choose their preferred payment method, such as direct deposit or a paper check. So for virtual credit cards, it's a relatively new topic that's already been passed in 56% of the states. If a dentist is going to be paid $100 for a procedure, they can receive a check that they can deposit in their account for $100, and therefore the dental benefit plan will have paid the full amount. If they accept a virtual credit card and process it through their credit card terminal, the fees are typically 3%, which is much higher than a standard credit card processing rate. And in some cases, the dental benefit company may receive a rebate on the fees that were paid out of it, and therefore not necessarily paying the entire $100 fee for the patient. This clearly is outside of what the intent of the ERISA law was. This is clearly just an administrative matter of payment between the third-party administrator and the dentist that provided the care. And I think this is, in Illinois, we have examples of dentists who continue to receive virtual credit card checks from the dental benefit companies, even though they have opted out through the proper mechanism, only to have Illinois' Department of Insurance say they will not look into it because of ERISA preemption. Again, clearly a huge overreach on the ERISA preemption. Network leasing laws, which has to do with how a dental benefit company will lease out its PPO network to other companies, again, has nothing to do with the design or administration of the dental benefit plan. And non-covered services, which is something that we have worked with NCOIL in the past to come up with a strong non-covered services law, which has been passed in virtually every state now. We also believe that there are laws that would trigger the preemption. In the last year, we've worked with NCOIL on medical loss ratio as it applies to dental benefit plans. We understand that that has to do with the creation and design of the dental benefit, and therefore would be fully preempted by ERISA. All right, turning back to the courts, I will bring up a little bit. Since Rutledge, there have been two cases that have gone to federal appeals court. One in the 8th District, where the court ruled that it agreed with the more narrow definition of the ERISA preemption as through Rutledge, and the 10th District, the 10th Circuit, excuse me, where the state of Oklahoma had sued, and the court agreed that there was a more broad interpretation of ERISA countering the Supreme Court. Currently, Oklahoma has petitioned the Supreme Court to take this issue up and to look into it to give clarity to this topic. The American Dental Association, along with a coalition of other healthcare organizations, has banded together to provide a brief supporting that the Supreme Court review this and give greater clarity to the topic. We at the ADA believe the Supreme Court should resolve the conflict and ensure consistent application of the law on the issue. Among the other groups, just to mention a few, we have optometry and all of the dental specialties, along with a couple other healthcare professions that have joined in to our petition, the amicus brief. At this point, in this case, the Supreme Court has called for the Solicitor General to review and give the federal government's opinion on this. We are hopeful that the Supreme Court will take up this issue in the next year. Regardless of the outcome of this, we believe that Rutledge empowers states to enforce dental insurance laws on carriers if preemption is not triggered. Rutledge on its own narrowed the scope of ERISA preemption, and the ADA is eager to work with other groups like the optometrists on behalf of patients and providers to ensure that state laws are enforced consistently. The time for departments of insurance to take a look at this is now, as recent estimates are that about 60%, 50 to 60% of dental coverage is being provided through self-funded plans. We are not against ERISA preemption. Rather, we support an appropriate narrowing of the preemption that empowers the states to enforce the laws that benefits the patients covered by the plans and the providers that offer this care. Thank you very much for your time today, and I'm happy to answer any questions that you have.
Thank you very much. And last but not least, Katie, go ahead.
Good morning, everybody, and appreciate you trying to listen to me after all these great presentations we've had so far, but we're about to get to the fun part with questions, I know, so I'll just try to stick to what I think will be hopefully helpful to put some context here. So I'm Katie Johnson. I'm the Senior Counsel for Health Policy with the American Benefits Council. By way of introduction, because I know there are so many groups to keep track of, the American Benefits Council is a national trade association that's dedicated to protecting employer-sponsored benefit plans. The council represents more major employers, over 220 of the world's largest corporations, than any other association that exclusively advocates on the full range of employee benefit issues. And our members also include organizations that support employers of all sizes. So these are the service providers and then some of the trade associations of the service providers. So collectively, our members directly sponsor or work with those who directly sponsor health and retirement plans covering virtually all Americans participating in the employer-sponsored system. Before we get to ERISA, which I know is the issue of the day, and I'm still processing the fact that Carmel tried to name her dog ERISA, so that's just still something I'm still thinking through because I'm jealous I didn't have that idea, but I don't know what my family would think either. So this is gonna feel tangential to ERISA, but it's the context I want to start with, and Melissa gave some great framing on this as well, but I did want to start just by emphasizing the critical role that employers play in the healthcare system, because that really is the foundation for everything else that I'm going to say and for all of the information that I constantly get from our employer members. As Melissa said, employers cover over or almost 180 million Americans, and said another way, more Americans rely on their employers for health coverage than any other source. But I do think that the value of employer-sponsored health coverage extends really far beyond just quantifying the number of people that are covered. It really reflects the commitment of employers to their employees. So my job, similar to Melissa's, is to talk to employers all day, every day about what they're thinking about, what they're worried about, policy, things they'd like to do, administrative issues they're having, the whole array. And what comes through constantly, like a through line, is their deep, genuine commitment to the health and well-being of their employees and their employees' families. And I wanted to note that their workers do recognize the value of this coverage. We did some polling recently. I'm sure I'm talking to a room of legislators, so I know everyone has different views on polling, but we did do some polling recently with the Winston Group, which is a polling group that we work with sometimes, and we did some polls about attitudes on the employer-sponsored system in September, so this is before the election. But in that poll, more than 3/4 of the registered voters that we talked to expressed satisfaction with their employer-sponsored health coverage. And in the same poll, by a margin of more than 3-1, voters with employer-sponsored health coverage preferred a system where companies provide comprehensive health coverage options rather than a stipend for employees to shop for their own health insurance in the individual market. And notably, only 7% of voters with employer-sponsored health coverage preferred a system where employers do not provide health benefits at all. I also wanted to make clear that these benefits aren't just valued by the employees who receive them, they're really, really valued by the employers that provide them. America's employers recognize that their investment in health coverage for employees is also an investment in their business success. Employers make this substantial investment with the understanding that the health and well-being of the workforce has a measurable impact on virtually every aspect of their business. And an employer's ability to recruit and retain talent requires a commitment to offering high-quality, affordable health benefits to an ever-evolving workforce. In fact, a study by Avalier Health that was done 2 years ago, I believe, estimated that employer-sponsored health insurance would provide a 47% return on investment to employers with 100 or more employees in 2022, and it was projected to rise to 52% in 2026. So I'm about to say a big number, but this includes $275 billion from improved productivity in 2022, and that was estimated to increase to over $300 billion in 2026. So employers are deeply committed to the health of their employees because they genuinely care, and also it's critically important for their business. I also wanted to emphasize that employers play a key role in lowering costs and increasing quality for employees and the healthcare system as a whole. And as Melissa alluded to, they've long been pioneering initiatives to lower costs and improve quality through various value-based design strategies. They do centers of excellence, care coordinators, special networks, you name it. They're always thinking of new innovations to try to help their specific workforce get the highest quality care possible in a way that is affordable and accessible. And so, why am I telling you all of this when we're supposed to be talking about ERISA? It's because the national uniformity under ERISA is the cornerstone of this highly valued employer-sponsored insurance system. Following the passage of ERISA, one of its authors that Melissa referred to cited preemption as the law's crowning achievement. And as Melissa noted, it's not just that this was politically necessary, right, in order to get ERISA to pass, but also those that wrote and passed the law understood that substantively this nationwide uniformity was necessary to underpin the employee benefits system. As you know, and we've talked about, and Chantel did a great job with, Carmel gave us a great overview of ERISA and jurisprudence, but I will just note again that employers that self-fund their health benefits can offer coverage across the 50 states that's consistent and tailored to the specific needs of their workforce. With ERISA's preemption provision, Congress protected these self-funded employers from a patchwork of state laws that would undermine these benefits. For 50 years, as Melissa mentioned, it's ERISA's 50th anniversary, ERISA and the employer-sponsored health insurance system secured upon its foundation have withstood extraordinary challenges, including an unprecedented pandemic and dramatic changes in the workforce and in the economy. And based on what I hear from our members, the importance of ERISA preemption for employers has only grown over time, and this is because in their view, commerce has increasingly stretched across state lines. The pandemic, which resulted in enormous growth in remote workers, has resulted in more mid-size and even some small businesses finding themselves now to be multi-state employers. Moreover, the need to innovate has become more paramount as employers continue to seek new strategies to lower costs, improve health outcomes, and meet the nation's healthcare challenges. I also wanted to note that in honor of ERISA's 50th anniversary over this past year, we did undertake some research with the Employee Benefit Research Institute, which is sometimes referred to as EBRI, so that's who I'm referring to if I do the shorthand. We held some roundtable meetings and focus groups with employers this past winter and spring to get their up-to-date 2024 view of ERISA preemption and ERISA more generally. And in fact, the issue brief from EBRI summarizing this research was released earlier this week. So I thought I'd take a minute to note the top findings from that research. It was a really interesting undertaking and always good to hear employers just actually speaking in a room and saying their unvarnished thoughts on an important issue like ERISA preemption. So I'm going to hit on a few of the top issues that they discussed. First, they said universally a major value of ERISA preemption for employers is that it provides uniform standards for employee benefit plans. So we've all talked about that this morning. This allows nationally uniform and central plan administration, and without ERISA uniformity, employers would have to comply with a patchwork of varying and ever-changing state and local laws. That would make it extremely difficult to administer a plan for a nationwide employer. And this is to say employers deeply value the regulatory certainty ERISA preemption offers. I agree with Melissa that if you get a group of large employers, our members together, and you ask them what's something you're most worried about, they would say potential threats to ERISA preemption. They think it's vital to their ability to continue to offer benefits. And so this is valuable, this nationwide uniformity, because it reduces the costs, though, also of providing benefits. And I just wanted to emphasize, when we talk about reduced costs, I want to be clear that that's for employers and employees. This isn't just that employers want, to minimize the amount they have to spend to administer their health plans. It's that any additional costs that employers have to pay in administering their health plans will mean that employees will ultimately probably have higher premiums or higher cost sharing. So these are really relevant from the employee perspective as well. 3 top areas came up in terms of how this uniformity helps reduce healthcare costs. The first is that it reduces administrative burden and compliance costs. This is really important in today's environment in which employers and employees are so concerned with healthcare costs. As one employer put it, without ERISA preemption, they would have to double their staff or hire more consultants because it would essentially mean that they were turning their one health plan into 50 health plans. Second, ERISA preemption helps lower healthcare costs by allowing employers to leverage economies of scale, which is something a lot of the employers we spoke with mentioned. They have nationwide plan design, administration, and negotiation, and so they use the size of their plan, which is quite large oftentimes, to negotiate with vendors. And so when they're working with one vendor and they're negotiating for all the covered lives in their health plan, they feel that they have the most leverage to get the best deal and are worried about undermining that if they were to have to deal with different populations and different vendors. Third, several of them mentioned that ERISA preemption also helps address healthcare costs because it allows employers to improve healthcare outcomes with the plan designs that they work really hard on intended to improve quality and outcomes. Another major benefit that ERISA preemption has from the employer perspective is fairness and equity for employees. I wanted to emphasize this point because it did come up with, I think, almost everyone. I'm picturing in my mind's eye some of these focus groups from this last year, and many of them were concerned about the situation where 2 different employees doing the same job, living 2 states away, would have different benefits. They're concerned about employees' views on that in terms of fairness and equity. They've grappled with that issue in some other areas. I don't know if any of you deal with state and local paid leave laws, but a lot of the employers we work with are very concerned about employees living in different states having a substantially different paid leave just because of where they live. And so equity and fairness is something that really drives their desire to have consistent benefits nationwide. Employers also really value ERISA preemption because it allows them to innovate with their plan designs and to provide customized benefits targeted to their workforce. Our members are pretty diverse. They have different geographic areas where they operate, different ages of their employees, different gender makeups, all kinds of things you can imagine, white collar, blue collar. And a lot of our members will have pretty different benefits that are pretty specific based on the type of employer that they are, and they work hard to make sure that that fits their workforce best. And I think they're worried that in the event that there is a 50-state patchwork of laws, it will be impossible for them to continue to design these benefits specifically for their workforce. Lastly, something I wanted to note that employers brought up in this EBRI study, these focus groups, is that ERISA preemption also supports the mobility of employees. I think today employees are more likely to change jobs within an organization, is what I hear from these large employers. And sometimes someone wants a promotion, but they'd have to move to a different state. And they find that ERISA preemption and their ability to offer that employee the same health benefits in that other state really helps folks be able to think about, is that the right move for my family, and is that the right move for me in my career, without having to think, oh, I'd love to take that job, but I don't want to go to that state because I need the health care that is under the laws in this state. So they think it facilitates the transfer of talent to other company locations and opportunities nationwide, and that's something that they've indicated is really important. So with all this said, it should be clear that increasing state efforts to regulate self-funded employer health benefits is incredibly troubling for employers. For example, state laws regulating pharmacy benefit managers hinders the ability of employers to utilize a uniform drug benefit across its employee population. Equally troubling is what this trend may portend for other areas of state regulation of group health plans, such as with third-party administrators or other types of benefits like network design or cost sharing, value-based design. These are all things our members are really worried about. As to the topic of whether changes to ERISA are needed, because I know that was part of what teed up today's discussion, the American Benefits Council firmly believes in the breadth of ERISA preemption under current law, and that states currently lack the authority to regulate self-insured plans, even when the regulation applies indirectly to a plan through regulation of the plan service provider. So we believe that the current ERISA standard is very, very strong. I know Randall and Carmel did a great job of updating us on some of the different circuit precedent that's happening and percolating in front of the Supreme Court, but our view is that ERISA currently is very strong. I wanted to note two other things, and then we can get to questions. One is the waiver concept. Just wanted to agree with Melissa that it's highly problematic from our perspective, which should be clear from what I've just said in terms of how much employers value the uniformity and the ability to provide nationwide benefits. Anything that runs contrary to that really, really undermines all of the things they kind of hold most dear in the benefit space, and so that would be very troubling and something that we would not support. But I did want to zoom out a little bit. Kind of the last thing I wanted to say was I want you to know that we also understand that there are a lot of really important health policy issues that exist today, and all of our members are constantly thinking about them, and that's really my job, is to talk with the employers, like how do you think we can improve the system? What are your employees struggling with? How can we do things better? And so we also, I think, probably all agree that employees should have access to high-quality, affordable health coverage, and that you want your constituents healthy, and we want our employees healthy. So I think on a high level, a lot of alignment. I think where the difference resides is, which policymakers are in the right position to address some of these really important issues that we're dealing with. And so we focus our efforts at the federal level. I wanted to make that clear. Melissa did a great job of mentioning a few things, but I wanted to be clear that, we understand that there are problems out there. So Melissa mentioned, for example, some states are trying to increase transparency efforts through all payer claims databases. We can't support that at the state level because we can't deal with 50 state all payer claims databases. But we've been super supportive of transparency efforts at the federal level. And so in some of these issues, it might be that we agree more transparency could improve quality and lower healthcare costs. The question is how to do it. And of course, we feel very strongly that it needs to be done in a way that doesn't undermine the ability of employers to provide health insurance coverage. On the last point that, Carmel made, and I think a few of us have alluded to, the idea that ERISA was supposed to be, this kind of retirement-focused law, and I know it's old, it's from 1974. I did just want to amplify a point Melissa made, which is it is really an important health policy law at this point. It's been amended several times, every few years, and health plans, self-insured health plans, are really, really regulated at the federal level. So I also didn't want to give the impression that we're saying, okay, we don't think states should be able to regulate self-insured plans, and that means that we are free from regulation. We can just do whatever we want whenever we want it. That's not true at all. I could spend all day just listing the laws that apply to self-insured health plans, and they've all been incorporated into ERISA. So we are highly regulated at the federal level, and we spend a lot of time trying to make those laws better. And in some cases, that even means advocating for new requirements on us. We were supportive of more transparency requirements for group health plans to try to improve healthcare costs and healthcare quality. That's something new we have to do. We've been supportive of the No Surprises Act to stop surprise bills, which mean that we have to do more and different things and go into arbitration and do all kinds of stuff. We support that because we thought that surprise bills were a public policy problem that needed solving. So I just wanted to be clear that we know there's a lot of issues out there, a lot of important health policy issues. Employers are actually really passionate about it. You'd think that like an HR executive at a big company is too busy to think about that, but they're deeply worried about the health of their employees, and they understand how hard it is to solve these problems. So with that, I'll just thank you guys for your time, and welcome any questions.
Thank you very much. And we are going to start the questions with Representative Dunnigan.
Thank you, Mr. Chairman. Carmel, is it Carmel? No. Earlier in your slides, you talked about the ERISA preemption applies if the employer's plan, or if the employer assumes full risk for the benefits. So how does that apply to partially self-funded plans where they have stop-loss insurance?
So that is a good question that I bet Melissa knows intimately. I believe that if you are a partially funded plan, you do fall under ERISA as well. But in general, the data that we focused on is for the fully funded plans.
So do you believe that the states can regulate the stop-loss portion, the insured portion of a partially self-funded plan?
That I haven't given enough time and thought to give you an answer on the moment about the stop-loss plans.
You tell me how this works. Am I allowed to
Yeah.
say something? Okay. Yeah, so that's a great question. I think the self-insured plan itself is subject to ERISA and ERISA preemption, and the stop-loss insurance would be regulated by whoever at the state level regulates a stop-loss policy. It gets complicated, as you know, with some plan designs that are starting to like kind of mush things together, and the Department of Labor at the federal level has started to think about, are some policies, they're look a lot like a stop-loss policy, but they're calling themselves a self-insured plan. So there's some question about the gray area, but technically, yeah, ERISA, I don't think applies to the stop-loss piece.
Thank you.
Representative Lehman?
Thank you, Mr. Chairman. A couple of questions, and one of my first questions was along the line of Representative Dunnigan. I do believe, well, we here in Indiana, I am in the insurance business. I don't do benefits, but I know this vein. We hear that even the partially self-funded, there's portions of that that are still ERISA-based, so we can't touch those.
Right.
So I guess kind of overarching all this, and I do think that the original intent of ERISA, we have gone way beyond. I mean, whether you like it or not, it's no longer a regulatory of retirement plans, it's a regulatory of health plans. Federal regulation of a health plan. So the first question is a health policy an insurance policy? If it truly is an insurance policy, then McCarran-Ferguson says that's in the hands of the states. If it's an insurance product, it is regulated by the states. So ERISA, I think, has overstepped its bounds by going into the space that should be regulated by the states. So the kind of the general arcing question here is, I'm hearing this fear. What do you think the states are going to do? Do you think the state's going to say, you know what, you've come up with these very unique plans to lower health care costs. Those are all gone. We're not going to use those anymore. We don't like those anymore. Aren't they going to look at that innovation and say, yeah, that's great. You can continue to do that. These state regulators are saying, we are trying to find ways to lower health care. Everybody runs on that issue, right? Everybody in this room probably ran on, we're going to lower health care costs. But then you go to your state, and in our state, we went from probably 70% of private market, 30% were self-insured, to almost completely flipped in the last 20 years. So now you have a 30% window of truly funded plans, and we go in and we're going to do this with PBMs and do this with this and this with this. And we hear you're only going to affect 20% of the plans because you can't touch that other 80%. So how are we really lowering healthcare costs if we no longer have any control once it touches that ERISA rail? And ERISA is just gripping these regulations and saying, we're not about to give them back to you, the state of Indiana, the state of Ohio, the state of Oklahoma, because our fear is you will do something drastic. And I've had employers say, love my plan, but there are some things I don't get a chance to do because I'm stuck in that ERISA lane. So the ask is, if it's truly an insurance product, and it should be regulated by the states, McCarran-Ferguson was very clear, then what is the fear of those regulators? And I'll say this, one last thing, then you can answer that. When you talked about 50 states, right, we don't want to go to 50 states or anything else. NEIC has the Interstate Insurance Compact. It works for life insurance, perfectly works for life insurance. You can go, you get your product approved one time, you can use it in all 50 states. Well, 46 of the 50. You know, so you have a path to say, here's my health plan, and you don't have to go to 46 different regulators, you go to one. So there's no reason health can't fit under the IAPRC, and that might drive other states to join just so they have that health piece in there. And it pulls it away from ERISA. So my general question is, what's the fear of letting states regulate this?
So, did you have a view on who you want to talk first?
That's for anybody.
Okay. So, thank you. A lot of good questions there. So the fear, I think, in my mind, it's like two buckets, and I'll shorthand it as like, you know, maybe a bad policy. Again, that's a shorthanded, right? So that would be a policy, like you said, we're afraid. Okay, we've designed our plans to have centers of excellence or special network designs or medical management, and the state says, we don't like you to do that. You know, we don't think that that's good for our residents, and we have some specific reason why that plan design worked. So I think we're worried about, we actually disagree with the state, and now the state can make us change our plan in that one state. I think the other category would be maybe good policy, but not 38, like, but not the right level of policymaking, if that makes sense. So I might say, I agree with you. I think PBMs should give more reporting and disclosure to employers. And we're advocating for that, say, at the federal level. But I don't want that done 42 different ways, you know, across the different states. So in my mind, that's like, we're afraid of both the specific policies might actually undermine our ability to choose how to design our plans. And then the other is just, it could be 50 good ideas, but it's 50 good ideas that then will be impossible for us to deal with. And so then we'll have to cut back our benefits or would really undermine our ability to design our plans. But on your other point on the insurance side, I want to be clear that I'm primarily talking about self-insured plans when there is no underlying insurance contract. Like when I mentioned this ERISA study that we did with all these employers, they all self-funded their plans. And so they basically are saying, we want to continue to be able to self-fund our plans because that gives us the most flexibility. They're worried about a world in which they would have to move to fully insuring because these are huge populations and they save a lot of money by self-funding.
So maybe just to follow up on that, and Ellis can answer this, would you support the states being allowed to regulate partially self-funded plans, as Representative Dunningham brought up?
If there's an insurance policy, like we don't have an opposition to the fact that even under ERISA, states can still regulate insurance. You know that, so we think under ERISA, states can still regulate insurance, and stop loss, I think, is insurance. So that's not something that we push against.
But we can never touch that middle part.
The part that's the self-funded plan, yeah, that's for us. No, I'm going to repeat myself, but that's our red line. You know, so I'll keep saying that. But no, we do not support state regulation of the self-insured portion.
So even though an insurance piece is put into the puzzle, you still don't
On
think the
top of, yeah.
regulators should be able to have access to that other piece of the puzzle?
Right. And I intellectually, you know, I want to be, it's good to have an open, honest conversation, right? Like, I hear what you're saying. I understand the tension. If you're saying, if there's 30 million people in my state and 20 million of them have this kind of health insurance I can't touch, and I want to help the people in my state, I get that. Like, I understand that frustration. That's why I tried to finish my remarks by saying, we're trying to say, let's make good policy at the federal level so we can both allow employers to keep self-insuring, but address some of the policy problems that you guys are grappling with. Yeah.
I just want to touch on this because, you know, being from the dental segment, which is its own unique animal in healthcare, as we're talking about self-funded plans, I can tell you from my experience and what we see in the state of Illinois, the vast majority of self-funded plans are third-party administered by dental benefit companies. Okay, so it's not dental benefit companies that are keenly aware of what Illinois' insurance laws and regulations are. So it's not a direct interaction with the company. The company has contracted the TPA, and it's the TPA and their interactions with the provider that is our concern. That is fully outside of this. This is the, you know, I'm not going to name companies. These are the companies that put their own restrictions on it that have nothing to do with the plans that were designed by the employer and meant to be implemented to the employees. The one example I'll use is the state of Illinois employees, all their dental plans are administered under Delta Dental, which, by the way, when you talk about uniform benefits, Delta Dental's fee schedule at my zip code is different than the benefit that a state employee would receive in Chicago or elsewhere in the state of Illinois. So it is, even on the dental side, that ERISA benefit is not uniform at all. It is subject to Delta Dental's fee schedule based on the zip code of the provider. So in general, what we're concerned about is how the TPAs handle their business relations with the providers. And that's where the state dental societies and the ADA are concerned. How can we make sure that those interactions follow state law? Because Delta Dental and the other companies know how to deal with Illinois. This would not impact the state of Illinois or a large employer, Boeing or whoever, in how their administrative side or their costs would be handled. The other factor on this, and I'll concede, usually the plans in Illinois that are union plans that deal directly, that the unions themselves, those we have no issues with because they tend to follow our state law and write paper checks and do all of that stuff. It becomes the third-party administrators that we have the issues with.
So I'll jump in here because I feel like this is just begging me to talk about an issue brief that Eric recently released, calling on Congress to clarify that ERISA's fiduciary duty requirements in law apply in full to the service vendors who are operating on behalf of that plan sponsor. And what you're talking about is exactly, you're making the case for me, man. That's exactly what we're talking about here, is that under the fiduciary duty requirements of ERISA, plan sponsors have a fiduciary duty under law to the plan. And it's really not that hard to oversimplify it. It's protect plan assets and don't do anything stupid, right? Don't go and gamble away the plan money or, hire your own family members to run it. Just be a good person, right? Now, the problem that we've seen, and we've seen court cases start to pop up in a very active plaintiff's bar, is that when plan sponsors contract with third parties, whether it be PBMs or TPAs, they are essentially treating those third parties as if they're standing in their shoes, right? The plan sponsor is not going to be the one negotiating all the different network contracts to build their benefit. The problem is that fiduciary duty obligation does not extend through that contract in full to those third parties. And so what Eric is calling on for Congress to do is just to literally make a clarification in the current law in the fiduciary duty section of ERISA that says when you're standing in the shoes of a plan sponsor, you have the same fiduciary to the plan that plan sponsor does when you're making your decisions, designing your benefits, figuring out how much to pay your network providers. We think that would clarify a lot of the issues we see crop up with the bad practices from PBMs and TPAs. And we're going to be pushing Congress to make that change. I don't know, Katie, if you wanted to say anything too, but I did want to make that point that we hear you, we know it's a problem, we're trying to fix it.
Representative Ferguson.
Oh, thank you, Mr. Chairman. I have a waiver question. We're all very frustrated with the ERISA because, as Representative Lehman pointed out, the majority of the healthcare plans in our states now are ERISA plans. But what was originally set up to be a multi-state plan for companies has really evolved into a lot of intra-state plans. There are self-insured plans that only have employees within your state. So we've actually talked to Congress about trying to pass a waiver to say that those self-insured plans that only function within one state would have to come under the state insurance department. Is that a possibility that would happen? And I guess I'm trying to understand the waiver process. Can that only be done through Congress? Or, as you pointed out, a waiver might be temporary. Would we be better off passing a law in our state, like Arkansas did with Rutledge, and just fighting it all the way to the Supreme Court?
So I think your question is really great, in part because first I want to talk about the last thing you said, Representative Ferguson, which is you flagged that right now states do have a way to try to get things through, but it's a really unsatisfying, expensive after-the-fact process. If you pass a law and then you fight it all the way up maybe to the circuit court, maybe to the Supreme Court, and for the states you hope that you get a Rutledge feeling court as opposed to a Gobiel court, which again doesn't feel like a great path. Like a waiver would kind of let you have that conversation preemptively with a different branch of the federal government. Like you're not talking to Justice Roberts or Justice Alito at that point, you're talking to somebody at the Department of Labor to make your case about, okay, this is why we think we would be better suited to regulate this aspect of these plans as opposed to you guys. I think that the question about self-funded plans that purely operate in one state is really interesting. Right now, my read of ERISA is that there's no authorization for the Department of Labor Secretary to waive preemption. Like, they are sort of stuck with it the same way that you guys are stuck with it. And so if you wanted to make progress on saying, hey, you know, we hear what Melissa and Katie are saying, but if an employer is truly based only within one state, a lot of those concerns are mitigated. We should be able to regulate that group. I think that your options would be to try to get the waiver mechanism in place so that you could get a waiver, or work with Congress to try to get a carve out for those plans. But if you're already having that conversation with Congress about a carve out just for employers funded insurance that is limited to one state, then you might as well have a broader conversation about there are a lot of things that we can't touch that would be good to touch from a healthcare cost or a healthcare innovation perspective. Why don't you give the Department of Labor the ability to evaluate those requests?
I have one, or maybe two reactions there, right? One is just thinking that through. I mentioned before the paid leave construct, which we hear from a lot of our employers. So I think one reaction you might get just to noodle is, okay, so they're in one state, but they're in, 15 counties, and could the different localities impose different laws on that? I mention that because, again, in the paid leave context, employers are not just worried about state-by-state variation, but also a variation, say you're required to cover 20 weeks of paid leave in LA and 7 weeks in San Francisco. So I just note there's some concern about within the state if the regulation would be consistent or not. And I'm from the American Benefits Council perspective, we would not support any kind of exemption to ERISA preemption, but I'm just mentioning that's one thought that came to me about localities in case someone asks you that. Another is that I think the policy value of ERISA preemption is one major item you've already noted, right? The avoiding the patchwork of 50 state laws. It's also somewhat distinct in that it is employers who are going to great expense to self-fund these plans, and so they're able to make the plans unique based on their workforce demographics, and so that might be a piece of pushback as well, which is you're just in one state. But even though you're in one state, I might say I know best how to design the insurance benefits for my population because I'm their employer, and I know about them and I know about their families, and I want to be able to design these benefits because I'm the one who covers all the risk. There's no insurance company here, it's just me, and so that might be another vein of pushback.
Yeah, I mean, there are many state-based plans that function in multiple counties. I don't really see that as an issue, but thank you.
Representative Oliverson.
Thank you, Mr. Chairman. Yeah, so I think, in kind of touching on what Representative Ferguson was talking about, so I think my question is really more, I think I counted the word doing business in 50 states used in the presentations at least a dozen times. And I understand that is, to my understanding, that is the congressional intent behind ERISA, and that has consistently been what it was put into place for, was situations where employers had to deal with a patchwork of regulations across many states. But as Representative Ferguson points out, a growing number of ERISA participants in both of your organizations are single state employees that are only covered under one jurisdiction that would be subject to only one set of regulations anyway. And so I think what I'd like to know is, when we talk about whether ERISA has grown way beyond what it was originally intended, is there any congressional authorization, and by that I mean federal law, that would indicate that ERISA was intended to apply to employers doing business only in one state under one set of regulatory guidelines? And if the answer to that is no, and that essentially it's just been interpreted over time because the DOL has allowed it to go that way, does that run afoul of the recent Supreme Court decision ending Chevron deference?
So my impression, looking at the key statutory language, is that that language is silent on whether you would need to be located in multiple states. It purely looks at, is this an employer-sponsored benefit? So could you bring a Loper-Bright style case to the courts to say, hey, we think all the way back in the day, Department of Labor overstepped by attaching it to this particular cohort of single state? I suppose you could, and I will say I have a lot of colleagues who teach administrative law who now are like, we know nothing, we can predict nothing. I would suspect that because it's been such an established part for so long, as well as the difficulty of, okay, some of these folks, like right now, are single state. Maybe next year they open a branch like across state lines and then all of a sudden they're not. Like, I'm not sure if a court would jump to say like, yes, this was an overstep by the Department of Labor, because I think ERISA was largely focused on the style of the plan as opposed to exactly how broad its geographic reach was.
Yeah, I would agree. I mean, I think, Katie, check me here, but I think the whole concept behind ERISA, and you may have heard us say, oh, you know, across 50 states, and that's why preemption is important for national uniformity. And that was clearly contemplated as a trade-off, right, and getting ERISA enacted 50 years ago. But I think the statute itself is, the preemption, all of this is triggered once you become an ERISA plan, right? A self-funded plan per se. It's based on the type of plan, and then the preemption follows. So I think what you're talking about is like right now, and I've heard this anecdotally, I don't know, I don't have any studies like Katie, data yet, but there, you know, anecdotally, there's a lot of fully insured small and middle, you know, medium-sized employer group plans out there that are considering self-funding. So you can imagine if you own a business and you have, you know, 55 employees, they're all in your state, and you decide to offer a self-funded health plan, are you now ERISA, and you're subject to ERISA preemption and everything else? So I think you're posing a good question. I don't want to misspeak about the actual law, but I think I agree with you that it attaches once you are recognized as an ERISA-covered plan, if that makes sense. I don't know, Katie.
Yeah, I agree. And I guess, I agree with you, Carmel, like on I know, the Harvard law professor, so that's who you should listen to, that's not me. But I do think that I would frame it differently, not that ERISA's necessarily silent on it. Like, I think it's broad, like Carmel said earlier. I don't think that right now, I don't see a part of the ERISA preemption language that ties it to being in multiple states. On your Loper-Bright question, I just wanted to mention maybe one technical item to consider, which is that, you know, that case primarily is about the ways in which a party can challenge federal regulations, and most of the law on the confines of ERISA preemption is set out in court cases, not regulations. So there's a lot of things Melissa and I do where I could tell you like thousands of pages of regulations, and we could talk about interesting Loper-Bright issues all day long. In my mind, for whatever it's worth, I don't put ERISA preemption in that category because it's not really a regulatory creature. It is more of a judicial creature at this point.
So if that's true, then I guess I'm confused, because what I've heard from several of you today in your presentations is that as members have asked questions, we keep going back to this whole concept of, you know, it's all about the fact that it's a patchwork of regulations and interstate and all this kind of stuff. So it feels strange to me that we're arguing in favor of ERISA preemption on the basis of interstate, you know, companies that have employees in multiple states, but at the same time we're saying that's not actually what the law does. I think it is what the law does. I think if you go back and read the law, that's exactly the problem they were trying to solve. And I guess going back to you, Carmel, I'm interested. So do you believe that if Congress passes a law and it's implemented badly, but the bad implementation persists for long enough that essentially that overrides the original congressional intent?
Wow, that's quite a position you're asking me to commit to.
Well, I'm just curious, because I
Yeah.
mean, because to my way of thinking, I think the best way to answer some of the questions that we're posing is for somebody to file a state law and force the courts to define this issue of whether this is designed to regulate health benefit plans that are offered in multiple states by the same employer, or if it's just anybody who submits an application that sort of, walks like a duck and quacks like a duck, we're going to give it the same broad-based immunity based on the idea that we're trying to ensure regulatory conformity, and so hence we're carving the states completely out and just doing the federal government. And so that's the direction we're trying to head. I mean, I feel like we're in a circular argument, so that's what I'm just wondering, like, did this law just get implemented badly? And so because the precedent is a bad precedent, that essentially now we're just gonna kind of let it go as opposed to going back to what the original congressional intent was?
So I think a lot of things have changed since 1974, including health insurance. And so I don't know whether it's fair to say, okay, from day one, the choices made in ERISA were bad choices. But I think it is fair to come back and say, okay, 50 years later, healthcare spending and access to healthcare has reached such a different fevered pitch as the gentleman, I'm sorry, I forgot your name, was talking earlier. Like, a lot of you guys have constituencies that are really, really concerned with the cost of their health care. And I think a lot of you guys are feeling the pressure to come up with innovative solutions as opposed to small Band-Aids. And so I think it's fair to go back to Congress as your federal counterparts and say, like, hey, we think that the time is right to revise. Maybe it looks like adapting the language. Maybe it looks like adding in a waiver. I'm not sure, you could try to file a court case. I'm not sure whether you would be successful or not in saying, okay, like from day one, the Department of Labor should have never applied its ERISA preemption and ERISA regulations to plans that only existed within a state. And you could try, you might argue it on Loper Bright, Corner Post, which is another case that was decided this term that didn't get a ton of attention, also kind of extended the look back for regulations that impact people from, like, basically that case said, like, from 4 years from implementation of the regulation to 4 years after you've been affected by that regulation yourself. So I think there is appetite to look back. I think you could possibly take a Department of Labor regulation that they then applied to these single state entities to be like, look, see, the Department of Labor took like reporting from a single state entity, and therefore they've made the choice and position that single state entities appropriately fall under ERISA. But I think at heart, you don't find geographic scope language in ERISA. And maybe that was because they wanted to encourage more single state employers to think broad and think multi-state. But it would be different if there was language saying, okay, the Department of Labor shall determine when you have enough people in different states to become an ERISA plan. I think you're just not going to find that much to hang your hat on with language that you have from right now.
Would I be wrong in asserting that that's part of what the court was looking at in the Chevron case, that situations where Congress is not clear enough and not explicit enough and just sort of says, well, we'll pass a law to regulate X and, agency go figure it out, that you just can't do that anymore?
Yeah, so Chevron stood for the proposition that Congress issues statutory language. The agencies are in charge of taking that language and interpreting that and implementing it. So like you think of the ACA is basically a game of Simon Says, but it's the Secretary of HHS shall. Chevron said, okay, we think that there's some unique expertise and insight in these agencies for their scope and their area. So if they interpret the statute and it's a reasonable, non-arbitrary and capricious one, we as the courts need to let it stand, even if we would have personally chosen a different path. And what Loper Bright says is courts shouldn't feel beholden to that. You no longer need to argue that the agency was arbitrary and capricious and basically irrational. You can just immediately go to the like, okay, well, what do we think this statutory language says?
Representative Tedford?
So my question basically was along the lines of what Representative Ferguson was saying. So not to re-ask that question, but I think what, in my opinion, what's happening is the self-funded market has developed so much over time that it's become accessible to smaller and smaller employers, and now employer 75 employees could go to a health insurance company and buy their partially self-funded plan and then have an ERISA plan. I don't think that was ever foreseen or intended by the drafters of ERISA, and I think that's a lot of what we're dealing with. If it was 77% of the state's plans were ERISA, probably wouldn't be having this discussion, but it's such a large percentage that it's drawn notice. And so, two questions I would have is, one, is there data on the percentage of ERISA plans that are single state? And then the other question I would have is maybe the answer here. The fact that someone's buying through a health insurance company a partially self-funded plan, it doesn't really create a burden on the employer if there's a compliance issue because it's handled by the carrier themselves. And maybe the answer here is this, as Randall had mentioned, this narrowing of the preemption down to when it's being administered by a TPA or something like that, to not preempt laws against that TPA and just on the employer itself. So maybe someone can comment on those two questions.
So I don't have the data on how many ERISA plans now are single state, although I imagine somebody on this panel would. But I think one point that needs to be flagged is 1974 was way before the ACA. And I think that the employer mandate kind of changed the incentives and the calculus for employers to participate in the health insurance markets. And that might have fueled some of the growth in interest in ERISA plans, self-funding in single state ERISA plans. So in terms of the TPA preemption question, I believe that there are a fair number of cases that basically say okay, the TPA is acting as the agent of the plan. So right now the jurisprudence doesn't put a lot of daylight between a TPA and an ERISA plan. But I agree with Randall's point, the whole point of the TPA, who are often insurance companies who also offer these services, is to know the ins and outs of their health insured. You talk about GoBL, and the TPA there, I believe, was a Blue Cross Blue Shield. They were reporting data for their own plans. They know how to do it. It was not such a burden on them, but it was an underlying choice by Liberty Mutual that felt uncomfortable providing this data.
All right, thank you. Unfortunately, go right ahead.
I was just going to reiterate. I mean, that is it exactly. I mean, those are the real annoyances. And from dentistry's standpoint, what we have done for the last 15 to 20 years in trying to tighten up insurance regulations centers around this issue, and that the TPAs, the dental benefit companies, are using the ERISA preemption to get around some minor administrative things that they don't want to deal with. And that is unfair to everybody who's put in the time to pass these laws, and it's unfair to the patients that usually end up being the ones that get shortchanged on this. So I think that's a real problem that needs to be cleaned up in ERISA.
All right, thank you all. Unfortunately, that's all the time we'll have for questions. I apologize if we didn't get to yours, but I would encourage you to reach out to the panelists if you'd like to get an answer. Thank you all for participating, all the legislators for your question. And up next is NCOIL NAIC Dialogue right here at 11. We'll take a quick networking break and then meet back here. Thank you.